This Honorable Court of Appeals is now in session. Please be seated.
Good afternoon and welcome. We're pleased to have all of you here this afternoon. While we have 3 cases listed on the docket, the third case has been continued, so we will hear the first 2 cases in the order in which they appear. Each side has 15 minutes to argue. The appellant has the right to reserve up to 5 minutes for rebuttal. So when you come to the podium after you introduce yourself, please let us know how many minutes you wish to reserve, and the clock will be programmed accordingly. As you know, the Court of Appeals of Tennessee is one court. There are 12 of us who come from 3 grand divisions, but we all sit in the East, Middle, and West with other colleagues, and we're honored today to have Judge Kenny Armstrong of Memphis, Tennessee, to sit with us. If there are no announcements, I will ask the clerk to call the first case.
Thomas Builders, Inc. versus CFK Excavating, LLC.
Good afternoon.
Good afternoon.
My name is Tim Burrow with the Nashville Bar, and I represent Thomas Builders, Inc., and I would like to reserve 3 minutes for rebuttal, please.
3 minutes, yes, sir.
Okay, in this case, the trial court erred by not vacating an arbitration award, and this is an appeal of that error. And the basis of denying the award comes from the Federal Arbitration Act, 9 U.S.C. Section 10A4, where the arbitrator exceeded his powers. In this case, the arbitrator exceeded his powers in 2 ways. One, by not honoring the arbitration agreement, which incorporated one of the AAA rules that required a concise written financial breakdown. The second example of exceeding powers was that the arbitrator based his decision on a fact that was a mistake of fact, non-fact, or had no support. And that fact was that there were 101 truckloads of unidentified material that was awarded when that material had no support in the record that it was soils that was compensable.
I'm sorry, say that again. When nothing in the record that it was what?
Nothing in the record to say that the unidentified loads was any soils.
Any soil?
Any soils, S-O-I-L-S. And only soils, unsuitable soils, was compensable under the contract. And that was $83,000 worth of
Let me ask
material.
you, Mr. Burrow.
Yes, sir.
Where do I find in the contract that it's the unsuitable soil that's compensable?
That would be, I believe, the last page. I don't have the contract right in front of me, but I might be able to find it. But there's no dispute on that fact, Your Honor.
Well, obviously, there is a dispute.
Well, I don't think there's a dispute that only unsuitable soils is compensable. There's a dispute. They're claiming that the unidentified loads was soils. But I don't think there's a dispute as to whether only unsuitable soils were compensable. But if it helps the court, Your Honor, that it's on the record, page 40. It says undercut. Undercut's the same as unsuitable soils.
Well, is that what, does everybody agree that that's what undercut means?
Yes, undercut and unsuitable soils is the same thing.
And where do you get that definition for undercut? Because as I understand undercut, where you're talking about excavation, it's unsuitable material. It may not necessarily be soil.
Well, undercut, the daily reports divided the truckloads, and this is in the record, the statement of evidence by the trial court, that what was removed from the site fell into 2 categories: topsoil, undercut soil, unsuitable soil, and no identification of what was hauled off. Now,
Unidentified material, right?
yes, unidentified material.
And let's suppose, for the sake of this discussion, that when you're excavating, you find old tree roots. That would have to be removed in order to start construction, wouldn't it?
Well, I'm not sure, but whether that was compensable, there's nothing in the contract that says that's compensable.
But the contract doesn't say unsuitable soil, it says undercut, doesn't it?
It says undercut, yes.
And doesn't that mean any material that is not suitable for construction?
No, it doesn't.
Well, where do you take your definition?
Okay, well, on page 40 of the record, undercut, 1,000 cubic yards and replaced with structural fill. So structural fill is structural fill soil.
But what is undercut, which is my question? What is undercut?
Well, it's undercut soil. I don't think there's a dispute, Your Honor, as far as what undercut means.
Apparently there is. Because he's asked you that question 3 times and you haven't answered it yet. We're not here picking sides, we're just trying to get to the facts.
Okay, on page 29, it says work, erosion control, grading, undercut. So if it's just undercut that's compensable, then there's even more. The entire $152,000 was not awardable, not just 83. That's even a bigger mistake of fact.
But is there a definition of undercut?
I don't see it in front of me, Your Honor.
Okay.
Which means
Then
there's
do we-
even a bigger mistake of fact. That means $152,000 of the award was not compensable.
Well, let me ask you, if they had labeled what was removed as undercut, rather than calling part of it unsuitable soil, part of it unidentified material, would you have any argument that you'd be making against payment?
I would not. If everything removed was undercut, then no, there would be no argument. That'd be $152,000 worth of undercut that is compensable.
But your argument comes into play because some parts of it they call unsuitable soil, and the other part they call unidentified material.
Well, it's divided into 4 categories: topsoil, undercut soil, unsuitable soil, and then no identification at all. And so I'm giving them the benefit of the doubt that all soils, CKF said that all soils removed were unsuitable and therefore compensable. There's nothing in the record that says unidentified truckloads were even compensable. There's nothing in the record that says that, or that it's any type of soils that would be compensable.
But let's suppose it's not soil. Let's suppose it's rocks and stones and tree roots, whatever. Can you build on that, or would that have to be removed before vertical construction would start?
It depends on where it is. I mean, if it's under the building, probably not, because there were deep piers that were designed where you could disregard whatever the stability of the soils was when you have deep piers that go into the ground. If it's under the parking, perhaps you have to take it out. It depends on, you would have to get a geotechnical engineer to look at it and decide whether it comes out or not.
And did we have a geotechnical engineer in this case?
Yes.
Did that person testify?
That person did not testify, but his letter was introduced into evidence where that engineer said that soils under the building did not have to come out, and that was part of what was awarded.
Okay.
So in this case, what we have is the arbitration agreement incorporated one of the AAA rules, American Arbitration Association Construction Industry Rules of Arbitration, R47B, which says, in all cases, unless waived by agreement of the parties, the arbitrator shall provide a concise written financial breakdown of any monetary awards. In this case, the ruling was a one-line item. It wasn't a concise written financial breakdown. The one-line item was, quote, $191,490.78 for work in place, a number that includes withheld retainage from previous payments, end quote. That's all it was. If we preserve the sanctity of the agreement, the arbitrator is to provide a concise written financial breakdown. Now, the parties agree that that number includes components, and the components are retainage of $22,837, Also, loads removed, the parties agree on this number, $152,279. Now, if you subtract that from the $191,000, there's a gap in there, we don't know what it is, of $16,374. So I contend that in this case, there had to be a financial breakdown of at least 3 areas. And that's before you even get into breaking down the $152,000 as some of it being unidentifiable. Even with laying that argument to the side, you should have a breakdown of 3. Now, for this court's guidance, between opposing counsel and me, there was only one case found that addresses the issue of that arbitration rule, that AAA rule of concise written financial breakdown. And that case is Bayport Pipeline, Inc. versus Adesta Commons. And in that case, there were actually a breakdown of 4, and the court found that that was sufficient. But that court relied in part on the AAA, the American Arbitration Association Construction Industry Arbitration Training Manual, that said, quote, in breaking down concise written financial award, a breakdown, you should, quote, itemize the components of each party's claim and counterclaim, end quote. In that case, they had a breakdown of 4. $1.5 million in cost other than equipment, $1.8 million in cost of equipment, these are round numbers, $445,000 in interest, $118,000 in attorney's fees. So it was those 4 items, and then they offset that with back charges that the other side asserted. So for this court, what I just relayed to this court is all this court needs to make a decision that they exceeded its powers by not providing a financial breakdown. I don't think this court needs to get into how many pieces there should have been or what they should have contained. It's just this court only needs to decide that a 1 line item is just not enough. And it's important.
Is the proper remedy that we just strike it completely, or do we remand it to the arbiter to make the concise breakdown?
Well, Your Honor, when you look at the statute, that's 9 U.S.C. Section 11, it gives the situations where you remand, and one is where there's an evident material miscalculation of figures, or an evident material mistake in the description of any person, thing, and so forth. There's 2 others that don't apply. That would be the closest one, and Your Honor, I interpret that to mean as almost like a mathematical miscalculation. So in my opinion, the Federal Arbitration Act does not allow a remand. It has to just vacate the whole award. Now, I'd like to emphasize the importance of the sanctity of the agreement. And I came across this case, and I'd like to read a part, and I think it'll be helpful to the court. I did not cite it in the brief because I stumbled upon it just in the last few days. The case is a 6th Circuit Court of Appeals case, Solvay Pharmaceuticals, Inc. versus Duramid Pharmaceuticals, Inc., 442 Federal 3rd, 471. Do I have just 6 seconds left?
From your original time, yes, sir.
Okay, so I better be quick. Can I just have the rebuttal at 2 minutes and take another minute?
Well, how much time did he reserve?
3.
3? All right. Any objection, counsel? All right, we'll give you 2 more minutes, and that'll limit your rebuttal to 1.
Okay. Okay, so the second one was the non-fact. And the non-fact is a fairly easy one. That is that $83,000 of the award was based on material that was unidentified. We agreed that there was $152,279 of loads that were removed. We agreed that CKF should be paid for unsuitable soils removed. The record shows that there were 4 categories: topsoil, undercut soil, unsuitable soil, that's 3 in soils, 1 in unidentified material. And CKF testified, this is in the statement of the evidence by the trial court, CKF testified that all soil removed is unsuitable, just the soil. There's nothing in the record to say that the unidentified material was compensable, yet the arbitrator awarded it, and that was $83,000 of it. Thank you.
All right, thank you, sir. You'll have 1 minute on rebuttal. We'll now hear from the appellee, Mr. Hutchison.
Thank you, Your Honors. My name is Ross Hutchison, and I'm here today on behalf of CKF Excavating, LLC out of Cumberland Furnace, Tennessee. And as identified by the appellant, there are two primary issues upon which the final and binding arbitration award has been appealed. The first one being the lack of at least that their position is that there was a lack of a concise financial breakdown. And the second being that the arbitrator somehow exceeded his powers by not providing that breakdown, leading to what I at least could have construed to be a mistake of fact or an error in the calculations. There is also a third issue before this court. It is CKF's position that we are entitled to attorney's fees under multiple statutes. We've requested those all the way dating back to arbitration at the trial court level, and here we are again today. But we believe those are entitled to CKF as a result of the frivolous appeal and the protracted refusal of the appellant to satisfy the award and judgment. So here we are. But I think it's important, I think it's most important to just look at the award. This is a 10-page award. There's no request by either party that we have even a reasoned award or an explanation of the award or a findings of fact or a findings of law. The only request by the parties was that we have a concise written financial breakdown. So we've got a 10-page award. If you look at the award, starting at page 2, the arbitrator starts outlining the various claims. There are a number of claims. There were affirmative claims on my client's behalf. There were counterclaims on behalf of Thomas Builders. And so we've got the CKF work claim. That work claim was for $191,000 and $191,490.78 to the penny. That claim was supported in a pre-arbitration brief that's been made part of the record that provides an outline of pay applications provided from my client to the appellant. Provides an accounting of the money that was paid relative to those pay applications and the money that was not. Those pay applications have detailed line items that include all of the elements within those pay applications. So the arbitrator had this information, looks at the pay applications as a part of the hearing, and ultimately decides that's the work claim, which includes this soil issue or this undercut issue. And Your Honor, to your point or your question about undercut, undercut is the removal of unsuitable material. As your question alluded to, it can be a number of items. You're just getting the base down to build out of.
Where does your definition of that come from?
Your Honor, there's nothing in the record that suggests that. I think more or less it's construction common knowledge. There's nothing in the record that would provide us a definition for that, for this purpose anyway. But back to what the arbitrator actually provided for in his award, he starts outlining these claims: the work claim, a statutory claim that we had, claim for attorney's fees, claim for interest, their claims for delay, number of items. And then in section 3 of his brief, on page 4, he starts sorting through those issues, looking at each individual claim and deciding upon them. Ultimately, he lands on awarding my client to the penny what they requested in those pay applications. He's looking at the work as a whole, which includes the removal of unsuitable materials. He, in fact, states, and this is more to the second issue as to whether there was a mistake, and really the appellant's position in this court that there was some type of error or really a disagreement on the number of trucks that were removed and what was in the trucks. The arbitrator stated, a decision on how many cubic yards of unsuitable soils after the fact were removed from the project can be the subject of expert witness testimony, such as a third party conducting a topographic study. CKF's position was that it kept up with the cubic yards and contemporaneously informed TBI in writing of such amounts, truckloads, and there would be change orders via email and daily reports provided to TBI as well as on-site discussions. It is not a credible defense or argument for TBI to argue that it had no duty or reason to review or timely respond to such communications. Goes on to state, TBI also spent considerable time providing new after-the-fact analysis with various charts to attempt to prove that CKF was overpaid, CKF removed soils that did not need to be removed, and or that CKF had not removed the amounts of unsuitable soils claimed. There was insufficient proof on these arguments to impact my decision on how much to award CKF for the work in place. That is, the arbitrator has already answered this question. He's looked at these facts. He heard all the testimony. He saw all the documents. And it's our position that it is not the place of the Court of Appeals to go back and look at the facts. It's not the place of the trial court to go back and look at the facts that the arbitrator had the opportunity to review. It's the purpose of arbitration to hopefully expedite the legal process and ultimately land on a final and binding decision.
Where are the calculations in the arbitrator's ruling that justifies the award of the $191,000? Where do we find that?
Your Honor, what he did at page 10, summary of the final award, he provides the calculations that incorporate a number of the items from each of those claims, and providing both credits to CKF and deductions based on how he decided the claims, ultimately landing on the award amount. So it's our position that the arbitrator provided us more even than we requested, but certainly satisfied the requirements or the requests of the parties for a financial or a concise financial written breakdown.
What about the $16,000 gap that Mr. Burrow's talk about? I mean, do you agree that there's some gap in the computations?
Your Honor, to be frank, I don't understand what Mr. Burrow is talking about. I never saw any evidence that indicated that, and I don't think the arbitrator had it. I don't know where those numbers come from and how he figured that up. I've not seen it, and it wasn't argued at arbitration, so I'm not sure. Now, let's see. The important part, I think, for this court to understand, beyond the discussion of the facts, the underlying what happened, what was actually removed, is the threshold to overturn an arbitration award. It's a mighty high hill to climb, and I think most of us understand that. And I certainly communicated that to the appellant on a number of occasions. It's according to Nationwide Mutual Insurance versus Home Insurance, it is one of the most narrow standards of judicial review in all of American jurisprudence. And importantly, as long as the arbitrator is even arguably construing or applying the contract between the parties in a proper way, then there's no basis to overturn the decision. I think that we have more than an argument. I think it's very blatant that he enforced the contract as written. But even if we have just an argument, then that's enough to satisfy the standard and not have our award overturned. And that really goes to the third point. We've requested fees, and under Tennessee law, I believe we're entitled to them. This is a frivolous appeal. This has been ongoing for over 2 years. We've attempted a number of times to move past this. We've had our award. We had a final judgment with the court, and I've reminded the appellant on a number of occasions of the highest standard and seeking some type of justification for overturning this award. In my opinion, this attempt by the appellant had no reasonable chance of succeeding. And under Tennessee law, that's the basis. So it's our opinion that we would be entitled under 27-1-122 to attorney's fees.
So let me ask you, is there any way I can just look at the arbitrator's report and actually do the calculations that leads to an award of $191,000? I mean, what pages do I look at to figure out the components of this award?
Your Honor, if you start at page 2,
Page 2?
yes, the arbitrator outlines the $191,490.78. That's the work claim. And so that's where he's formulating. We put up in arbitration, we put up proof to establish this $191,000 and change as our work claim. Those go back to the pay applications that were incorporated into the pre-arbitration hearing briefs. And so he outlines that. That's our claim. And so he's essentially working backwards from our claim. Thankfully for my client, he didn't work too far. In fact, he didn't reduce our claims by a penny because he looked at the proof and found that we provided sufficient evidence that supported our pay applications. I think that answers your question. What makes up that 191 number, he does not include in the brief or in the award. But again, those numbers are supported by line item pay applications that were incorporated as a part of the pre-hearing briefs that are a part of the record.
But you can look at page 10 of the award, right, and come up with the 190,1078, and then that would be less the amount of the bond, the $1,000 bond, correct?
Yes.
And you get the same number.
Yes, Your Honor, and I think that goes to the Bayport case that I've cited in my brief and Mr. Burrow mentioned. If you look at that decision even, you're still floating general terms. You're not getting into the nitty-gritty of what every dollar means or where it comes from. You could get very, very detailed. And I would suspect that Thomas Builders, if there had been some of that nitty-gritty detail included in the award, they'd be saying, well, that's not nitty and gritty enough for us. You know, there are a lot of elements that go into a project, and dollars can originate from a lot of different areas. So even in the Bayport case, they're working in general terms. They're talking about, you know, contract claim or retainage, interest, things like that. They're not getting into the nitty-gritty as to what that number entails. They're providing very general terms, just like they did here, just like the arbitrator did here. The arbitrator here provided us the work in place number. Then he awarded them the bond claim, removing that from our award. Denied interest, denied attorney's fees, but it's a working way to resolve the number.
And then, what's the status of the Rogers claim currently?
It is still pending in county next over. Okay. But it is currently pending. The money is in escrow. We've sought for it to be released, and the appellant has refused to allow it. I have nothing further, unless you have any questions.
Thank you, Mr. Hutchison. Mr. Burrow, your 1-minute rebuttal.
Okay, the $191,000, there was never a breakdown of that. That was their claim. That was on page 2 of the arbitration award. That's not a breakdown. That was just their total claim. And it was reduced by $1,480,
But in the footnote in your brief, you were able to mathematically show where that number came from.
Yes, that's right.
Because you're able to pinpoint exactly what work orders this comes from.
Yes.
And that's how you make your argument that that's uncompensatable, because it's unidentified soil.
Correct.
Versus what you say is undercut.
Right. That's correct. So, but he didn't, the
So
arbitrator
there's
did not.
really no mystery about where the numbers come from.
Well, if you dig and try to figure it out, but the sanctity of the agreement, the arbitrator has to break it down for this reason. When he came to damages, he just gave a number. He didn't analyze the damages. If you require a concise written financial breakdown, you're requiring the arbitrator, and it's very important that he goes through this process line item by line item. And had he done that and come upon the unidentified loads, it's like, well, how much did we award for that? Well, wait a minute, that's $83,000, which needs to be reduced from the $152,000. So yes, we can go back and figure it out, but it's the sanctity of the agreement. An arbitrator, when you pick an arbitrator, there's a high risk there.
All right, Mr. Burrow, sum up, please.
Okay, all right.
I could tell you're getting wound up, and I don't need to cut you
No,
off.
and I could talk for a long time, but he basically did a well-reasoned award, and then when he got to damages, there was nothing there. It was just, we're just going to give him everything. And that is the problem. It's the
But you know the
sanctity of
components
arbitration
of it, don't you, Mr. Burrows?
I'm sorry.
You know what the components of the 191,000 award
Yes.
is. I mean, it's set out in the report.
I say I do, but there's still that mystery 16,000. And then when you divide it by the components, that flushes out, wait a minute, there's $83,000. That's a mistake of fact, non-fact, and no support. So it's either the one or the other. Well, actually, it's both.
All right,
There's no breakdown.
Thank you, Mr. Burrow.
Just one other question.
Oh, please, yes.
Let me ask you, even after CFK discontinued work on this project, there was still unsuitable, you can call it whatever you want to call it, soil, material, whatever, but there was still unsuitable material that had to be removed before construction would start. Isn't that right?
Yes.
But somehow you complain about this other material removed by CFK, and you say they shouldn't be paid for it.
Yeah, because there's nothing to say that it was unsuitable soils. Just because there are unsuitable soils left in another corner of the lot or wherever that you found doesn't mean that something you took away in another place was unsuitable soils. That's a gap in logic.
Okay.
Yeah.
All right. Thank you very much,
Thank
Mr.
you.
Burrow and Mr. Hutchison, for your arguments. We will take the matter under advisement. Call the next case, please.
Aaron Solomon versus Angelia Solomon et al.